So just to give you an idea, Andrew covered the basics of water rights, prior appropriation. I know Ross, he's back there laughing. Prior appropriation and riparian doctrine and the differences there. This next part of this presentation, what we're going to touch on is the basics, the actual step-by-step processes to show you what an application goes through, or if you file, when you're going to file an application, what to anticipate. So this morning we'll cover the application process, and we'll actually get into the legal framework, the statutory criteria for those applications. Chris is actually going to come up after I talk about that to talk to you about proofs, certificates, and title. And then just after lunch, Willa is actually going to cover some of the basic elements that you need to provide to file an application. So we'll really get into the nuts and bolts for this next portion. We also, later this afternoon and then tomorrow, we'll get into some more of the specialized processes that applications go through, the more special topics. So just to give you that idea, but before we take a break, we have just a quick video that is going to start getting you thinking about what happens when an application is filed. So we'll go ahead and play the video.
This video is part one of a three-part video series describing the administrative process that is followed for water rights applications. This multi-step flowchart you are seeing was created many years ago to visually diagram the process from filing to certification. We will use this chart in the video series to describe the administrative steps that are completed once a water right application is filed. Part one of this video series covers the application process from filing to decision of the state engineer, which is shown in the first portion of the blue section of this chart. Part two of this video series describes what happens to an application after the decision is rendered and the administrative remedies parties may seek if they disagree with the decision. This is shown in the second part of the blue section of this chart. Part three of the video series covers the administrative process once an application is approved with established time limits and the applicant works to complete the proposed project and fully place the water to beneficial use. Now let's take a close look at the beginning of the process from filing the application to a decision by the state engineer. As authorized under Utah Code Title 73, Chapter 3, an application to appropriate, permanent change, or exchange application can be filed. The application can be received by either our main Salt Lake office or one of the 7 regional offices across the state. If the received application is determined to be acceptably complete with the appropriate application fee, it is filed and the information becomes available on the division's website and a master file jacket is created. If the received application is not acceptably complete, it will be returned to the applicant with an explanation of the deficiencies. Determining that an application is acceptably complete does not mean that the information it contains is correct. It only means the required information has been supplied for an application to be filed. The master files for all applications are stored and maintained in our main office in Salt Lake City. The application review process begins in the regional office that has oversight of the geographical area where the application is proposing to divert and use water. Once an initial review of the filed application is made, the regional office staff will then designate the application for advertising in a newspaper of general circulation in the county in which the source of supply is located and where the water is to be used. In some instances, applications may need to be published in more than one paper. I should point out here the importance that the applicant ensure the application they are filing is correct. If there are errors or corrections made after the publication, the application may need to be re-advertised. This will cause a delay in the process. Applications are advertised for 2 successive weeks. Administrative Rule R655-6 designate adjudicative proceedings of the Division of Water Rights as informal. Therefore, any person interested may file a protest within 20 days after the notice of the application is published. After the publication is completed, a proof of publication is sent by the newspaper to the division to confirm the publication did occur as required. There are limited circumstances defined in Utah code that may not require the publication of an application. An application for a small amount of water, which is defined as 1 domestic, quarter acre of irrigation, and 10 equivalent livestock, is at the discretion of the state engineer. These types of applications may not be advertised. However, notice of these applications will need to be given if the proposed application for a small amount of water may impair existing rights. Temporary change applications are another type of application that notice is not required. However, in the case of a temporary change, if there is reason to believe it will impair an existing water right, it will be denied. After the application is advertised, the protest period has ended, and the proof of publication has been received, the regional engineer will make a preliminary review of the application and all documents and information. This preliminary review would include a policy review, potentially an initial field review, and data collection. If the regional engineer determines there are now additional parties, protestants, to the application, and there isn't sufficient information to determine if there is reason to believe the application meets the statutory criteria within Utah Code Title 73, Chapter 3, that is applicable to the type of application they are reviewing, an informal administrative hearing will be scheduled. Administrative Rule R655-6 gives authority and defines administrative adjudicative proceedings of the Division of Water Rights. The administrative hearing is scheduled with the Assistant State Engineer for Applications and Records and the Regional Engineer. At least 10 days' notice is given to all parties. Most hearings are held in the county where the water source is located or the county where the majority of the parties reside. Hearings may be held outside the county at the discretion of the state engineer. After the hearing, or if no hearing is needed, the regional engineer will then complete a full review of the proposed application and all associated data to determine if there is a reason to believe the application meets the statutory criteria to be approved. This full review may include a field investigation, review of the appropriation policy for the area, review of scientific data, and a full file review, including title of record with the Division of Water Rights, the protestants' concerns, and any additional information received before, during, or after the informal administrative hearing. Based on the regional engineer's findings, a recommendation is prepared and reviewed with the application and records section. A final draft decision is then prepared for review of the state engineer. The state engineer then reviews the decision, consults with the regional engineer and assistant state engineer. The state engineer will then render a decision to approve with conditions, or reject the application. The decision of the state engineer is served on all parties to the action. Part 2 and Part 3 of this video series will discuss the administrative procedures following a decision of the state engineer.
So that video actually is going to be available on our YouTube training site as well for future reference. But I wanted to play it before we take the break, just to get you thinking about what the process is. The next presentation that I will be giving will talk about the statutory criteria, that legal framework that we look at on applications. But that was a basic summary of once an application is filed to action of the state engineer and those statutory criteria that we have to meet once we have that application. So let's, now we will take a break and resume back at 10 o'clock. Is that correct, James? At 10 o'clock, and I'll talk to you more about some of the legal framework. So we'll see you at 10. It's after 10, and so this next portion that I'm going to cover, that video that we showed covered the process that an application goes through once it's filed to a decision of the state engineer. And maybe I should introduce myself, who I am, who you have talking to you. So my name is Teresa Wilhelmsen. I'm an assistant state engineer over the application and records section within our division. Andrew described us briefly on the employee chart that we have there. And so you're going to hear from me for a few minutes here, and then you're going to actually hear from Chris York, who manages our certificate and proof program, but also our title program. And then after lunch, you'll hear from another member of our staff, Willa Knight, who is in our public inquiry section, and she's going to help you with some of the basic elements for an application. But my portion of this, we're going to talk about application approval criteria and the legal framework that we go through. And I'm just going to reiterate just a little bit. Andrew covered a couple of these types of applications that we deal with. And in that first video, I mentioned that we were focusing on, for the process, applications to appropriate, change applications, and exchange applications. Those are our three most common applications that we do see in the division. But applications to appropriate, all of the decisions that we make that come out of the state engineer's office, there is a legal framework within Utah code that guides us in how we are to look at applications. Some people may think we get an application and whether we like you or not is the decision, but that is not the case. Every application goes through the same process, and there is a legal framework that we have to follow, and hopefully I can help you understand that. But applications to appropriate most generally are within Title 73, Chapter 3 of the Utah Code, and it's actually Section 8 where you see the application to appropriate criteria, and I'm going to cover that quite in detail for this presentation. Utah Code Section 73.3.3 covers change applications. Temporary changes, you'll see that criteria within Section 73.3.5.5. So you kind of see a theme here, Title 73, Chapter 3 for appropriation of water. And there are various sections within that chapter that cover these types of applications. Fixed time applications are actually in 73.3.8, so Section 8. And then exchange applications are under 73.3.20. Just to give you a basic idea that there are various sections within that Utah code applicable to each of those applications. So the process that I showed, or that we did that video, which this was the first time we've done a video like that, and it was kind of a little odd. My sound studio was a sweater on my desk surrounded by a microphone. And so it was an interesting process, but I hope that it conveyed a message to you that every application goes through the same process within our division. And that red box shows what that first video covered. At the conclusion of my presentation, I'll play you another video that we did that covers that second portion of an application to kind of help you get through. But I did really quickly just want to cover a couple elements that I picked out of that first video that I think you should be aware of, especially if you're taking a test tomorrow afternoon, I guess it is. One of the important elements is if an application is protested. So there is that 20-day period when an application is protested. Just because an application is protested does not mean that application is automatically denied. We still go through the process to look at that application and the data that has been submitted to us. So if an application is protested, it is not automatically denied. Another element to keep in mind, I talked about when a hearing is required. Well, those administrative hearings that we hold, and I'm actually the division's hearing officer, they're an informal process. So while attorneys, in many cases, participate through those hearings, they're not required. Someone can participate them and represent themselves in those hearings. So no, attorneys are not required in a hearing to represent all parties. So, and I have a question back here, but you're going to have to wait for a microphone.
From past history, when an attorney has been present to represent one of the parties, have you sided with the attorney? I remember with the party that has the attorney over and above someone without an attorney more often?
No. Yeah, good question, but no. We looked at the fact. We would look at the facts and the data that's presented. So let me go ahead and jump into the approval criteria. And actually, I'm going to go right back to this slide here. So in that video, we ended with the state engineer making a decision and whether it was to approve with conditions, or reject that application. So what do we look at when we evaluate an application? So the approval criteria, with every application that we review, there is a standard that we evaluate that data by, and it's called a reason to believe standard. So you have a kind of this reasonable suspicion, which is is the lowest burden to overcome, and then the highest burden is more beyond a reasonable doubt, right? Well, the reason to believe is just above that lower standard. So if we have an application filed with us, that applicant just needs to give us a reason to believe that that application can be approved as it meets the statutory criteria. Then an applicant can compel us with the additional data that application does not meet that statutory criteria. But in keeping in mind whether it's an application to appropriate, a change, an exchange, we use that reason to believe standard when we evaluate applications or the data that is before us. So stepping into the legal framework for applications that we review, under Utah Code Title 73, Chapter 3, Section 8, it states that it shall be the duty of the state engineer to approve an application if there is reason to believe. There's our reason to believe. The first element that we look at is, for an application to appropriate, is there unappropriated water in a proposed source? So this section, or this portion of code applies to applications to appropriate. And is there unappropriated water? Do we have reason to believe there's unappropriated water in that source? There was a prior court case that did, and it's just mentioned on this slide for your reference, but is there unappropriated water? So we'll evaluate those applications. In most cases, there are specific area policies, and I think someone asked me this at the break, is there unappropriated water in the state of Utah? There are policy-specific criteria that have determined in some areas there may be limited amounts of water that can still be appropriated. This map that you see, you'll find on our website, and it actually identifies areas that are open to appropriations, some that are restricted areas where maybe that's just available for small domestic applications, and then definitely areas that are closed, that are very over appropriated. And in those areas, you can't do an application to appropriate. You would need to do a change application to convert an existing right to the new use that you're proposing. So something has to be given up under that change. But this map is available for you to refer to on our website. So another criteria that we look at under Section 8 is, will the proposed use not impair existing rights or interfere with a more beneficial use of water? So we need to make sure that those proposals, those appropriations or those changes do not impair existing rights or interfere with a beneficial use. Stepping into another section, for temporary, and I'll just point out temporary change applications. As of 2015, temporary changes had a slight alteration to the statutory criteria. Temporary changes are not advertised, and in the video we talked about that, and there is no hearing. And the main criteria that we would look at for a temporary change application is if there's reason to believe it will not impair, But if we believe it will, that application will be denied, and someone may need to pursue a permanent change so that we can actually evaluate that more deeply, get public comment, and investigate the issue more closely. So temporaries do have a little bit different process that they go through. One of the key things here, if you're not sure on a project and you're thinking a temporary change application may be appropriate, you might want to visit with the regional engineer in the area where you're working, and they could probably help you know, yeah, that's not going to work. You probably just want to do a permanent change and not even mess with that temporary change route. So we definitely can have pre-application consultations with folks. That's actually in statute, but we've always done it. But feel free to talk to that regional engineer to help you know the best direction for you to go with your proposal. Lynn, wait for the mic, Lynn. Wait for a mic. Sorry. You're good. He's right over there behind you.
Is there ever a time when a temporary change application would need to be advertised?
By statute, they are not. So we would deny that application if we felt it was going to impair.
Is there a definition for temporary, like 3 months, 4 months, half a year, that will say is probably more beneficial to have a permanent one? Is that based on
So
time frame?
temporary applications to appropriate and temporary changes are for 1 year. Yep. Yeah, so if you've got a project that's a much longer term, you probably want to do a permanent change application. So this next slide, we talk about, there is a new element within the change application framework, which is in Utah Code section 7333. And it talks about that if a change does not impair an existing right, if there may need to be just compensation or adequate mitigation made, but a change should not impair. And later today, I believe it is, we're going to get into a lot more detail on quantity impairment and a rebuttable presumption of quantity impairment that are defined within those two sections, that 7335 A and B. So I'm just going to gloss over, mention it to you, and I think it's Mike Drake is going to get into that in detail with you, because that is an important element that is happening more and more in our change applications. And what we hear, recently we scheduled about 30 hearings in our Richfield office, and more than half of those had a rebuttable presumption of quantity impairment raised by a protestant. So it's becoming more and more common. We see it in Utah Lake every now and again, and then also down in our Cedar City office and in our Weber office in, I guess, Logan. So let me just name all those offices that we see it. But it is becoming more and more of an important thing to understand. So this is just a slide to kind of get you thinking about part of the statutory criteria. If quantity impairment is raised or a rebuttable presumption of quantity impairment is raised, it is the applicant's burden to prove that there is evidence that that has not occurred or that they can overcome that rebuttable presumption. But within that criteria, keep in mind that there are quantity impairment and then a rebuttable presumption of quantity impairment, and they are slightly different. And so I was just trying to, with this slide, emphasize that those are two different concepts, but very related. So another portion of Utah Code, section 7338, when we talk about appropriations, it does say that the state engineer shall reject a permanent change application if they're unable to meet that burden of overcoming that rebuttable presumption of quantity impairment. So it is important that the applicant participate in this process with their application. Statutory criteria, I mentioned it at the beginning. Exchange applications is another type of application that we see in our office. We typically get about 100 or 120 a year. And that particular section of code is 73-320. And an exchange application is typically filed when you have a diversion that from one water right and you're exchanging it for another, and there is no diminishment in quantity and quality of that water being exchanged. So you have one and you're giving it up to get another. And most of the exchanges that you see within our office are within the Weber River drainage, and they are based on contracts with Weber Basin Water Conservancy District. So that's the majority. You do see other exchanges in the Utah Lake area. There are a few in there as well, but most of the new exchanges are being filed in the Weber drainage there. So approval criteria, continuing on that, one of the third criteria that we look at is the proposed plan physically and economically feasible, and will it not prove detrimental to the public welfare? So that's the third criteria that we evaluate those applications by. Does physically and economically feasible, I talked again about that reason to believe standard. When you apply for an application, because of that reason to believe standard, you don't have to have complete drawings on your project, finance, all paid for. You just need to give us the reason to believe that it's physically and economically feasible. Another section, criteria 4 that we look at is financial ability to complete the proposed works. Does that applicant have the financial ability? If you're building a home, you probably do have that financial ability to do that. So that burden or that standard may be a little lower. If you're doing a nuclear power plant on the Green River, probably a much higher standard to show that you have that financial ability to complete that project. Here is within section of code 73.3.11. Here's some suggestions of the financial ability. Maybe you provide the articles of incorporation, names and places of the board of directors, capital, what is committed to that. So just a little bit of an example there. So criteria number 5, was the application filed in good faith and not for purposes of speculation or monopoly? Someone can't just come in and gather up all the water and, then start kind of becoming rich off of it. So the applications do need to be filed in good faith. There needs to be a project that's proposed, and they're not speculating over that water. There was a court case, and actually we have a question, correct? Get the microphone next to you.
I just wanted to clarify on one of your earlier criteria, the exchange application. The original water in such stream, body of water, or reservoir must not be deteriorated. For clarity's sake, does that mean that for general purposes, it's going to be within the same basic area? You can't you can't exchange something from San Juan County in San Pete.
Correct.
It's got to be within the same drainage, within the same water body.
Right.
I just wanted to clarify that. Thank you.
And let me actually add to that. So exchange applications, you pointed that out, that it needs to be within the same drainage. Permanent change applications, you wouldn't be able to file a change to move a water right from Utah County down to San Pete County. It needs to stay within that drainage that it originated. So thank you for that question. So back to good faith and not purposes of speculation or monopoly. In 2008, there was a case, and I'm just going to read this, that the state engineer concluded that the original application was filed for speculation or monopoly because the only proposed beneficial use of water was a plan to sell it to others. Indeed, the applicants had no lands, facilities, customers, or contracts. So that was, good definition of speculation or monopoly there. So the 6 criteria that we look at under that section of code, and this is if applicable, if there is a groundwater management plan that has been adopted in the area, does the application comply with that groundwater management plan? We could spend a whole training session about groundwater management plans, but we don't have one. But this is a criteria that was added to statute that applications do need to comply where there is a groundwater management plan. And there's the section of Utah code that describes groundwater management plans at 73.515. If you'd like to look that up. So continuing through section 8, if the state engineer has reason to believe that it will interfere with a more beneficial use or unreasonably affect the public recreation stream environment, be detrimental, the state engineer may hold that application until we investigate that matter. So this is just another criteria within that section that we just quickly point out. And again, 73.3.8, the public recreation, natural stream environment, we may hold those decisions until we further investigate that issue. So that is and I've got a summary slide toward the end here that will list each of those criteria that we look at, and then I'm going to kind of ask a couple questions about that. But hopefully that helped you see, when the state engineer evaluates an application, that legal framework helps us determine the action that we may need to take on an application. But also it gives guidance to the applicant. What do you have to show or what do you have to prove that your application can be approved? And then a protestant. What compelling information can you provide to help us know that maybe that application doesn't meet that statutory criteria? So let me just talk about hearings. And through this process, there's a little bit of that flow chart that video covered. When we hold administrative hearings. So kind of the purpose of those hearings helps us understand the application better, what's being proposed. But in addition, if we have other parties to that application besides the applicant, we have to have conversations with all parties present. And so these hearings help us do that and help us ask questions of the applicant, maybe ask questions of the protestants, or I should say, and ask questions of the protestants, not may. In most cases, we do ask questions of all parties to help us understand what they're trying to convey to us about this proposal. So when we schedule a hearing, the regional engineer will contact me. We'll pick a date that works for our schedules, and then we reach out to parties and send notice to all of those parties of when that hearing will be scheduled. Under the administrative rule of Utah Code R655-6, that outlines the criteria that a hearing, an administrative proceeding with the state engineer is governed by. And we may hold a hearing if it's requested in a timely protest, or those hearings may be held at the discretion of the division. Even if a protest hasn't been filed, we may actually schedule a hearing. If there are no other parties besides the applicant, to kind of make the process a little quicker, the regional engineer may just reach out to that applicant and actually schedule a meeting with them instead of a formal hearing. But it just depends on how we want to gather that information. The proceedings are informal, so an attorney is not required, emphasizing that again, that you don't have to have legal representation when you come to a hearing. The hearings, they are open to all parties, and the purpose of them is to introduce evidence to us to consider. examine and cross-examine witnesses, make arguments, and fully participate in the proceeding. So it does help us communicate that information and gather that information that we need to make a decision on the application. So a party to an application, for the person the party to that application is all respondents, all protestants, all persons that have made an appearance in this adjudicative proceeding. And we're going to talk a little bit more about that too, and that may be a question on your test, that a party to an application would be the applicant, the protestants, and the state engineer. So non-party participation. Persons can act as a witness for a party. Say an engineer or an attorney represents, or a geologist represents and comes and speaks on behalf of an applicant or a protestant. That engineer or geologist are not parties. They are a non-party participant in that hearing. So the party is the person, either the applicant or the protestant. Let's see. Administrative hearings. So if a party believes that they are aggrieved, and we're going to get the second video, we'll cover more of this, but if a party believes that they're aggrieved by the decision of the state engineer, there are remedies that application or that person can go through. And it's to file a request for reconsideration or a judicial review of that decision. So once a decision is made, there are some remedies, and you'll hear that in the second video that we've got for you. So again, purpose of the informal hearings is to gather data and information that's relevant for us to determine if this application can be approved, if it needs to be approved with conditions, or is the application to be rejected. And this slide just emphasizes those sections that we talked about. Unappropriated water, will it impair? Is it physically, economically? Is there financial ability? Is it in good faith? Those criteria that we evaluate those applications by to see if there's reason to believe that those applications that are before us meet this statutory criteria for approval. If they don't, then the application will be rejected. So as an applicant, this is what you're focusing on, helping us understand how your application meets this criteria. As a protestant, you're focused on helping us understand how it does not meet this criteria. You know, in a lot of cases, we do have protestants that maybe say, you know, we don't want this facility built here. It doesn't fit within zoning of the county. That's not something that we look at under an application. That may be a county issue. Or, you know, that this drinking water system needs to be approved or further approval. Well, that would be the Division of Drinking Water. So as an applicant and a protestant, I think the biggest message to take away is look at this criteria that we have, the legal framework to look at applications under or evaluate those applications, and make sure you're focusing on that and helping us understand. And we have a question right over here. He's right behind you with the mic.
I was wondering about the advertising of going for it. You can't have protestants if they don't know anything about it. So what are the requirements for advertising?
So we are required to put it in the paper, newspaper.
Which paper?
Of general circulation, where the application is to propose to be diverted and used. So sometimes it may be one paper or it could be two. Depending, and sometimes it's 3 and 4 or 5 and 6 where we have to advertise that paper. There is also notice on our website. We have what's called the new filings listing, and I think Jim might cover that at the tail end of tomorrow, some of the tools that we have on our website. But as you know, a lot of newspapers are consolidating. Some of the smaller papers are closing their doors, and so some entities do follow the new filings list. Plus, we also have another tool on our website that I'm sure Jim's going to cover, where you can subscribe and you pick a polygon, and any new point of diversion proposed in that area will send you an email. So there's various ways to give you notice, but by statute, our only requirement is in the paper.
Okay, thank you.
Okay. So there's the criteria. So let me talk about another element that folks need to be aware of, and that's division policy. So in all of the regional offices, I talked about groundwater management plans, and there's other site-specific policies for folks that are within an area to be aware of. This is just a map, again, showing the regional offices. But each of the region offices, most of these areas, if you go to our website, you click on that area that you're interested in, it will bring up all of the policies that have been put in place by the state engineer that govern an area. And this is just a very brief listing of some of those, just to give you an example. Salt Lake Valley, there's a groundwater management plan that you need to be aware of when you file change applications within the Salt Lake Valley. There's a Colorado River policy that affects a lot of applications in Andrew's area. Andrew spoke with you this morning. Endangered fish policy affects a lot of his decisions too. There's a special policy for the Weber Delta sub-area of the East Shore within the Weber River office. There's Milford and Black Rock policies down south in Nate's area. There's various water right policies within the Sevier River Basin in Kirk's area. And I can't quite read that. There's the last one on that bullet, but you guys can. Willow Basin watershed. So it just is kind of an example to let you know that there are various policies that the state engineer has adopted that you need to be aware of wherever you're working. And I would actually recommend just going out, taking a look, and making sure you're aware of them. So, but be aware of those site-specific policies. This next portion, I'm just going to go through. So we talked about an application by the state engineer is either approved or it's rejected, or it can be approved with conditions. And let me just talk about a couple of those conditions that you may see. I think a lot of times when folks get the order of the state engineer, they flip to the back and they look and see, does it say approved or rejected? And then they don't really look beyond that. But it's critical to read that decision of the state engineer. Some of the additional conditions that may apply, and in most cases do apply, there could be a condition that it's approved with the condition that diversion depletions are not exceeded from that historic, if it's a change application, that you're not exceeding those, and that reductions are made. Conditions that you have to meter, measure, and report. And you need to be aware of that if that is a condition of approval, you need to do that. Some of the others, you file a change application from one well to another, and there's no rights left in that well that you moved from. You will need to abandon that previous well. Maintaining shares. There's a type of application, change application that could be filed based on shares of stock in an irrigation company. If we approve those applications, you need to maintain those shares of stock. You can't sell them and continue to do that project that you proposed. You have to maintain those. You have to pay your assessments. If the water company, if you fail to maintain them, the water company could ask for a reversal of that decision by the state engineer. Retiring prior use, change applications again. You buy a right that was being used or is being used, and you want to propose a new use, well, something has to get given up in order to do that new use. You can't do both, and so you've got to retire that prior use and demonstrate how you've been able to do that. There may be municipal right considerations that proof, maybe a developer has filed a change application and has indicated that this water is now going to be used by a municipality, and we approve that. Say in this example on the screen is Lehigh City. That proof would need to be filed by the city. That developer would not be able to file proof because it's not their facility. The application actually would need to change ownership to the city. So that may be a criteria that you'll see. Distribution regulation. That application that you do may fall under one of our distribution systems. And Jared is going to talk to you, I believe, tomorrow about our distribution section. And you need to be aware that you may need to report and only take your water under the direction of that river commissioner. If facilities are not owned, there may be some limitations that are associated with that if they're owned by someone else. So I think that the message to kind of give you here is that there is statutory criteria that gives us a legal framework that we evaluate all applications by. And it does say that it shall be the duty of the state engineer to approve an application if there is reason to believe. And so it'll be an approval of the application, or it may be approved with conditions. If an application does not meet the requirements of this section, then it shall be rejected. Statute does say both of those. So it's either approved or rejected on those decisions that we do. So with that, that is the criteria that I was going to talk to you about in detail. And we are going to play that second video, which I think will emphasize some more of the issues. And I can take a couple questions as James is bringing up this video, and then I will take some other questions at the end of the video too. Oh, my dude has been diverted.
Real quick question. Back on the administrative hearings open to all parties, you mentioned the applicant, the protestant, and the state engineer. Was there another one in there that were the parties?
Those would be the parties to the application. Now, if somebody who hasn't filed a protest wants to attend a hearing, they certainly can. And we have been known to actually take testimony from
This video
them.
is part 2.
But for test purposes, those 3 names are what you're looking for.
Yes. Any other, a quick question, any other, or then we'll play the video. Okay, let's play this video, and then if you have questions after this, I'm happy to address more questions.
This video is part 2 of a 3-part video series describing the administrative process that is followed for water right applications. This multi-step flowchart you are seeing was created many years ago to visually diagram the process from filing to certification. We will use this chart in the video series to describe the administrative steps that are completed once a water right application is filed. Part 1 of this video series covers the application process from filing to decision of the state engineer, which is shown in the first portion of the blue section of this chart. Part 2 of this video series describes what happens to an application after the decision is rendered and the administrative remedies parties may seek if they believe they are aggrieved by the decision. This is shown in the second portion of the blue section of this chart. Part 3 of this video series covers the administrative process once an application is approved, with established time limits, and the applicant works to complete the proposed project and fully place the water to beneficial use. The water right application process shown is authorized under Utah Code, Title 73, Chapter 3, for appropriation of water. This flowchart process is applicable to applications to appropriate, permanent change applications, and exchange applications. There are other authorized types of applications that follow similar administrative steps or portions of these steps. However, this video is intended to focus on the administrative process for these 3 most common water right applications. For part 2 of this video series, let's now take a close look at what happens once a decision is issued by the state engineer and the administrative remedies a party has if they believe they are aggrieved by the decision. Once a decision is issued on a water right application, that decision may approve an application, reject an application, or approve an application with conditions that must be met by the applicant as they proceed with their proposed project. The decision is served on all parties to the application. All parties include the applicant and all the protestants to the application, and of course the state engineer. The decision is issued as an order of the state engineer. If the parties accept the approval of the application, including any required conditions, the applicant can then work to develop the proposed project to place the water to full beneficial use. As part of the conditions under which an application is approved, the state engineer will set a time in which the applicant shall construct the works, apply the water to beneficial use, and file proof with the state engineer. The time limit given is generally 5 years from approval of the project. For larger projects, additional time may be allowed. Part 3 of this video series will cover completing and proving the project is complete. If the state engineer does not have reason to believe the application meets the statutory criteria within Utah Code Title 73, Chapter 3 for approval, the application shall be rejected. If the parties accept the rejection of the application ceases. In some cases, a party to the application may believe they are aggrieved by the order of the state engineer. The order of the state engineer is subject to provisions of Administrative Rule R655-6 of the Utah Division of Water Rights and to sections of Title 63G, Chapter 4 of the Utah Administrative Procedures Act and Utah Code Section 73-314, which provide for filing either a request for reconsideration with the state engineer or for judicial review with the appropriate district court. A request for reconsideration must be filed in writing with the state engineer within 20 days from the date of the order. The written request shall be filed in person, by mail, or electronically. If the request is filed electronically, it shall be submitted to the authorized general email for the division, which is waterrights@utah.gov. When a reconsideration request is received, the division will send notice of the request to all parties and may, within 20 days from receipt of the request, deny or approve the request in part or in whole, issue an order, or rehear the application. If the state engineer does not issue an order within 20 days from the date of the request for reconsideration, the request shall be considered denied. A request for reconsideration is not a prerequisite for filing a judicial review. If the reconsideration request is granted, all parties to the decision are notified. Granting of a request for reconsideration sets aside the administrative decision on the application in its entirety, and the status of the application reverts back to the status prior to the order of the state engineer. The regional engineer then reviews any additional information and conducts further investigations to determine if there is reason to believe the application meets the statutory criteria for approval. Another informal administrative hearing may be scheduled. The result of this investigation and new determination is an amended order of the state engineer. The amended order is again served on all parties. If the parties accept the amended order approving the application, including any required conditions, the applicant can then work to develop the proposed project to place the water to full beneficial use. As with the original order, the state engineer will set a time in which the applicant shall construct the works, apply the water to beneficial use, and file proof with the state engineer. Part 3 of this video series will cover completing and proving the project is complete. If the state engineer does not have reason to believe the application meets the statutory criteria within Utah Code, Title 73, Chapter 3 for approval, the application shall be rejected in an amended order of the state engineer. If the parties accept the rejection of the application ceases. If a party still believes they may be aggrieved by the amended order of the state engineer, as with the original order, the order of the state engineer is subject to provisions of Administrative Rule R6 55-6 of the Utah Division of Water Rights and to sections of Title 63G, Chapter 4 of the Utah Administrative Procedures Act and Utah Code Section 73-3-14, which provide for filing either a request for reconsideration with the state engineer or for judicial review with the appropriate district court. The result of a judicial review will be a decision by the court. The decision may be consistent with the order of the state engineer, or it may reverse the state engineer's decision. If the court's decision approves the application, the applicant may proceed with developing the project. If the order of the court rejects the application will cease. A party may file for an appeal of the district court's decision with the Utah Supreme Court. Now let's look at the remedies if reconsideration was not granted. A party may, within 30 days, file for judicial review with the appropriate district court. Again, the result of a judicial review will be a decision by the court. The decision may be consistent with the order of the state engineer, or it may reverse the state engineer's decision. If the court's decision approves the application, the applicant may proceed with developing the project. If the order by the court rejects the application will cease. A party may file for an appeal of the district court's decision with the Utah Supreme Court. If the original order approved or approved with conditions and the reconsideration was not granted and no judicial review was filed, the parties accept the decision. The applicant shall then complete the project as approved and fully place the water to beneficial use within the time limit established in the order of the state engineer. Part 3 of this video series will cover completing and proving the project is complete. If the original order of the state engineer rejected the application, the reconsideration was not granted, and no judicial review was filed, the parties accept that decision and the application ceases. Orders of the state engineer approving an application will include a time limit in which the applicant shall complete the project and place the water to full beneficial use. Part 3 of this video series will discuss the administrative procedures following the approval of an application.
That second video was intended to help you understand what happens once a decision of the state engineer is issued. And if the parties agree with those decisions, or the administrative remedies if they feel they are aggrieved by that decision. And ultimately, once a decision is issued, the date that is served on the parties, then parties have 20 days to ask for reconsideration of that decision. They would file that with the state engineer's office. We send that notice. If it's not granted, they would then have 30 days to file a judicial review. Or if right at the beginning we issue that decision, they would have, and they don't file reconsideration, they would have 30 days to file that judicial review. So it's essentially just letting folks know, or the message to take away from this last video is that there are remedies that parties can seek if they feel that they're aggrieved by that decision of the state engineer. It doesn't just end there. So with that, I hope that gave you a brief summary.
We have a question from Cedar City, if that's all right.
Okay.
Can you go over the difference between quantity impairment and rebuttable presumption of quantity impairment again?
I certainly could, but they are actually going to get a whole presentation on that this afternoon. Will that suffice?
I'll answer for Cedar City, yes.
Okay, thank you. Any other questions before Chris comes up? Chris is going to talk to you about our, in that video series, kind of part 3, the proofs and certificates and some title elements. So we're a little ahead of schedule, but that's okay. You might get a little bit longer lunch. So Chris will come up and we'll continue to help educate you. Thank you.